Hello and welcome. If you're tuning in, you're likely focused on staying updated, especially with topics crucial for the UPSC Civil Services exam.
That's right.
Today we're doing a deep dive into something quite significant, the Supreme Court's recent look at the Waqf Amendment Act 2025.
Yes, this is definitely relevant for your mains current affairs. Think governance, social justice, religious freedoms. It touches on a lot.
And possibly prelims too, right? Understanding these legal and constitutional points.
Absolutely. The basics of Waqf law, Article 26, it could all pop up.
Okay, so let's define our terms briefly. Waqf, many studying will know this, it's essentially a religious or charitable endowment under Islamic law. Property or funds set aside.
Correct. For religious or charitable use.
So changing the laws around these waqfs, like this 2025 Amendment Act does, well, that's a big deal.
It really is, and it's drawn serious attention from the Supreme Court, which is what The Hindu reported on recently, our main source today.
Right. So our mission here is to unpack the key issues the court's looking at without drowning in legalese. We want to focus on the potential impact.
Exactly, and the scale is indicated by the fact that there are over 100 petitions challenging this act's constitutionality.
Over 100. Wow.
Yeah, and the bench hearing this includes the Chief Justice, Sanjeev Khanna, and Justices P.V. Sanjay Kumar and K.V. Viswanathan. They've already raised some pointed questions.
Okay, so what specific parts of the act are causing concern? Let's start with this term, waqf-by-user. What exactly does that mean?
Waqf-by-user basically refers to properties, think old mosques, community lands, that have been used for religious or charitable purposes for a really long time, maybe centuries.
But without formal paperwork, like a deed.
Precisely, often without formal registration. And Justice Khanna himself pointed out, many of these properties existed long before modern registration systems were even a thing.
Okay, so historical usage established their status. What does the 2025 Act do to them?
Well, this is the crux of it. The Act essentially eliminates the legal recognition for these waqf-by-user properties.
Eliminates it.
Yes. And the petitioners are arguing this could hit almost half the waqf properties in the country, maybe 4 lakh out of 8 lakh. It could basically erase their legal existence on paper.
4 lakh properties potentially losing legal status. That sounds like it could have massive consequences on the ground.
Oh, absolutely. Beyond just the property records, think about the heritage involved.
Right, the cultural significance.
Exactly. Community management, traditions tied to these places for generations. If they lose legal standing, it could spark countless disputes, undermine community structures. It's not just about land titles.
It's about lived reality and history meeting modern law, it seems.
That's a good way to put it.
Okay, another major flashpoint seems to be allowing non-Muslims into Waqf governing bodies. The Act permits them as ex officio members on the Central Council and state boards. What's the issue there?
So the court raised a pretty fundamental question here. Can religious institutions be governed, even partly, by people who aren't part of that faith?
I see. It touches on religious autonomy.
Right. The government argues it's very limited, just 2 ex officio posts out of maybe 22 members.
Only 2 positions.
Yes, but the principle is the key thing here. The petitioners, and seemingly the court too, are looking at Article 26 of the Constitution.
Which guarantees religious denominations the right to manage their own affairs.
Exactly. So does including non-Muslims, even in these specific roles, infringe on that right? That's the debate.
It's a tricky balance, isn't it? Inclusivity versus the specific rights of a religious group to manage its internal matters.
It really is. You could argue for diverse perspectives, maybe better oversight, but the counter-argument is potential dilution of the religious character or control, setting a precedent. It's a sensitive point.
Okay, let's move to the third big issue, the district collector's role. The Act gives them power to decide if a property is waqf land or government land.
Yes, and this immediately raised red flags for the Supreme Court, particularly around due process.
Due process concerns. Why?
Well, the court basically warned, can a government officer effectively act as a judge in a dispute where the government itself might be an interested party?
Ah, the potential conflict of interest.
Precisely. And is an executive officer equipped or mandated to follow the same kind of impartial judicial procedure as a court would?
So it's about fairness and the proper forum for deciding property status.
Yes, and again, the petitioners link this back to Article 26, arguing it infringes on the denomination's right to manage its own property by giving the state this power to determine its nature.
So given all these concerns, Chief Justice Khanna suggested some kind of interim measure, didn't he? Though it wasn't formally ordered yet.
That's right. He proposed a sort of three-point interim relief. First, properties already declared as waqf by courts, including these waqf-by-user ones, shouldn't be denotified for now.
Okay, maintain the status quo for those.
Second, investigations can continue, but the actual status of properties being looked into shouldn't change hands or be altered until the court finishes its review.
Right, hold off on final decisions.
And third, regarding the non-Muslim members, appointments could continue, but only if Muslims remain the majority on these boards.
So a kind of temporary safeguard across the board.
It seems like an attempt to pause any immediate, potentially irreversible actions while the case proceeds.
Makes sense. But you said it wasn't formally ordered.
No, the Solicitor General asked for more time to respond, so the court listed it for further hearing. It's still very much in progress.
Got it. So, summarizing the petitioner's main legal thrust, it's Article 26, the right to manage religious affairs.
That's the core constitutional challenge, yes. They argue these provisions violate that fundamental right.
And they're using past judgments, too.
Yes, they specifically mention the Ayodhya judgment, pointing out that it actually recognized the concept of waqf-by-user.
Interesting. So they see a contradiction there?
They do. And they also object to what they see as forcing Muslim donors to sort of prove the religious nature of long-standing practices, calling it parliamentary overreach.
Okay. Now, what about the government's defense? What did the Solicitor General argue?
Well, the government's stance is, first, that registration of all waqfs has technically been required since way back in 1923. So they frame this as enforcing existing requirements, perhaps?
Okay. Not entirely new.
Second, they stress the limited number of non-Muslims involved those two ex officio posts.
Right.
And third, they argue the collector's power is mainly procedural, temporary, and still subject to judicial review eventually.
So they're downplaying the impact and framing it as procedural cleanup.
Largely, yes.
Mm-hmm.
But reports suggest the bench seemed unconvinced on some key aspects, especially the potential impact on established rights and the waqf-by-user properties.
Okay, so let's try and pull this together. This deep dive really shows the Supreme Court grappling with the Waqf Amendment Act on several fronts. Key concerns are the fate of these historically used but unregistered waqf-by-user properties,
The potential denotification.
the inclusion of non-Muslims, even if limited, on Waqf boards, and what that means for religious autonomy under Article 26.
Right, that core principle.
And finally, the power given to district collectors and the worries about due process and conflict of interest.
That sums it up well. And for UPSC aspirants listening, this case is a perfect example of how legal changes interact with fundamental rights, governance structures, and historical practices.
Absolutely. It touches on separation of powers, state versus religious autonomy, key syllabus themes.
Understanding these dynamics is crucial. It's live socio-legal evolution happening right now.
It really makes you think about the long-term implications, doesn't it? For managing religious properties, for the balance between state authority and religious freedom in India?
Yes.
Which brings us to maybe a final thought to leave listeners with. What does this specific case, this friction point, tell us about how India is navigating the relationship between new laws, long-standing historical practices, and those fundamental constitutional guarantees?
That's a deep question. It certainly highlights that this navigation is an ongoing, often contested process of interpretation and balancing.
Definitely something worth reflecting on further. Well, that wraps up our deep dive for today. We hope this breakdown has been useful for your UPSC preparation.
We hope so too.
If you found this helpful, please do give us a like and subscribe to the channel for more analyses like this one.
And please leave a comment if you have questions or other topics you'd like us to cover.
Remember, our discussion today was based on that report in The Hindu, which is a great source if you want to read more. Thanks for joining us.